Has your tenant suddenly disappeared after locking your house or shop? Rent is unpaid. The property is locked. And you are thinking of breaking the lock? But wait, can a landlord legally break the lock and take possession? If you do this wrongly, you may face a criminal case instead of solving the problem. In this video, I will explain the correct legal position, Supreme Court rulings, and the safest procedure every landlord must follow. Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. Before moving ahead, I have a humble request to you. You may scan the GPay QR code and contribute 59 rupees or 119 rupee to become a member of this channel. You may cancel the membership at any time. Your small support will help in spreading legal awareness. Now, let us move ahead to the topic. Introduction. Has your tenant suddenly disappeared after locking the house or shop? Is rent unpaid? Are you thinking of breaking the lock and taking possession? The most important question is, can a landlord legally break the lock? Let us understand the correct legal position. Can the landlord break the lock himself? The first and most important point is that a landlord cannot break the lock on his own. If the landlord forcibly opens the premises, enters the property, or removes the tenant's belongings without following legal procedure, the tenant may file a criminal complaint upon return. The landlord may face allegations such as criminal trespass, theft, criminal breach of trust, mischief or damage to property. The Supreme Court has clearly laid down this principle in Krishnaram Mahale v. Shobha Venkat Rao, 1989, 4 SCC 131, where the court held that even a true owner cannot dispose a person in possession without following due process of law. The court emphasized that forcible dispossession is not permitted, and legal remedies must be followed. In other words, the Supreme Court held that where a person is in settled possession of property, even on the assumption that they had no right to remain on the property, they cannot be dispossessed by the owner of the property except by recourse to law. Role of police. Generally, police treat such matters as civil disputes. Therefore, police usually do not break the lock or restore possession. They normally advise the landlord to obtain an appropriate court order. Correct legal procedure. The landlord should first send a written notice to the tenant at the last known address mentioning rent arrears and absence. Thereafter, a written intimation should be given to the local police station stating that the tenant has disappeared and the premises are locked. It is also advisable to publish a public notice in a local newspaper calling upon the tenant to respond. Opening the premises through court. If the tenant does not respond, the landlord should approach the civil court and request appointment of a local commissioner. After the court order, the lock can be opened in the presence of the local commissioner, and a proper inventory of articles can be prepared. The Supreme Court reiterated this principle in Ramegowda v. M. Vardappa Naidu, 2004, 1 SCC 769, holding that a person in peaceful possession cannot be dispossessed except by due process of law, even by the true owner. In other words, in this case the Supreme Court held that a person in peaceful or settled possession of property is entitled to retain it, and cannot be dispossessed by the true owner except by due process of law. In the present case, the court has found the plaintiff as having failed in proving his title. Nevertheless, he has been found to be in settled possession of the property. Even the defendant failed in proving his title over the disputed land so as to substantiate his entitlement to evict the plaintiff. Important legal provision Section 6 of Specific Relief Act, 1963. There is also an important statutory safeguard. Under Section 6 of the Specific Relief Act, 1963, if any person is dispossessed without his consent and otherwise than in due course of law, he can file a suit within 6 months to recover possession. These Supreme Court judgments form the judicial backbone of this provision. Therefore, if a landlord forcibly breaks the lock and takes possession, the tenant may approach the court under Section 6 and seek restoration of possession within 6 months, irrespective of ownership rights. If breaking the lock becomes absolutely necessary, In emergency situations such as water leakage, fire risk, or safety concerns, the landlord should inform police in advance, call independent witnesses, record complete videography, take photographs, prepare an inventory of articles, keep belongings safely. These precautions help protect the landlord legally. Precautions in rent agreement to avoid such disputes include a local guarantor, abandonment clause, absence beyond 30 days, security deposit and post-dated checks, identity documents, inspection clause. Legal conclusion. A landlord cannot take forcible possession. Possession should be taken only with tenant consent or through court order. The Supreme Court judgments and Section 6 of the Specific Relief Act clearly support this principle. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.